It's time for the Newsmaker Show on News Talk AM 1480 WLEA.
Well, very glad to have on as our guest today a constitutional professor who's in the Who's Who listing for both Who's Who in America and Who's Who in the World. His name is Ralph Rossum. He teaches at Claremont McKenna College in California. Dr. Ralph Rossum, thanks for joining us today on WLEA in Hornell.
It's my pleasure. I'm looking forward to our conversation.
Ralph, you knew Supreme Court Justice Antonin Scalia, who died recently, and you wrote about him on the Liberty Law website. In your article, you said, quote, "In 1987, a year after Antonin Scalia's confirmation as an Associate Justice of the Supreme Court, only 7% of the briefs that were filed before the Supreme Court made an originalist argument. 20 years later, 35% of the court did so. This is no accident." So, Ralph Rossum, summing up what you were saying here, and correct me if I'm wrong, but summing it up, Scalia was able to bring some on the Supreme Court around to his way of thinking. Would you describe that as accurate?
Yes, very much.
And what was Scalia's way of thinking? That's the first question.
Well, he's identified with something called an original public meaning approach to constitutional interpretation. That means that he wanted to know what the words and phrases of the Constitution meant to those who drafted the Constitution in Philadelphia and to the delegates of the various state ratifying conventions that ratified the Constitution. He likewise, when it would come to something like the 14th Amendment or Bill of Rights provisions that were passed after the original Constitution was ratified, he wanted to know again, what did the words mean? What did the text mean to the society that adopted it? And he pursued that not only on constitutional questions, but also with regard to statutory construction, interpreting statutes. There was a big practice at the time he came on the court of when the Supreme Court would interpret a statutory provision, it would look not so much at the actual words of the statute itself as to a legislative history, to committee reports that were prepared to inform members of the Congress what the legislation really meant. And Scalia rejected that out of hand. Just as we had a substantial increase in the number of briefs that made originalist arguments, we had the exact opposite when it came to Supreme Court decisions that relied on legislative history. When he came on the court, 100% of all cases where legislative history could be cited, it was. 20 years later, it was down to 40%. Anytime a justice made a legislative history argument, he got his knuckles really smacked with a ruler by Justice Scalia in a concurring opinion or in a dissent. His argument was, the law means what it says. Congress, when it passes a bill, the president has to sign it. He has to sign it on the basis of what the words say. We as citizens have to obey it based on what the words say, and we shouldn't be going to committee reports to find out what words mean. It has to be clear on the face of it, and that was, again, a major contribution of Scalia, a new form of statutory construction that is textually based, not based on the intent of those who drafted the measures.
How was it that Scalia was able to influence the other justices on the court to come around to his way of thinking, or the originalist way of thinking?
Yes. It helped when Justice Clarence Thomas was confirmed, because Thomas is also an originalist. So suddenly you had two justices, which made it much more important for litigants arguing before the court to make an originalist argument, because there wasn't just one to influence, there were now two. But at the end of the day, when Elena Kagan was confirmed as a justice on the Supreme Court, during her confirmation hearing, she ended up saying, Today, we're all originalists. And no better decision highlights that than a decision, a 5-4 decision by Justice Scalia in 2008, District of Columbia against Heller. That was the decision in which the court held that the Second Amendment confers an individual right to keep and bear arms for purposes of self-defense. And Scalia made very much an originalist argument. He turned to dictionaries and encyclopedias of the late 18th century to find out what each of the different words in the Second Amendment meant. What did it mean to keep? What did it mean to bear? What did arms mean? What did a well-regulated militia mean? And what was interesting was the principal dissent by Justice Stevens became a dueling originalist argument. All 9 justices were arguing on Scalia's terms. 4 of them didn't agree with him, but they were making originalist arguments no less than Scalia. And so nothing, I think, highlights more so how pervasive his influence was than that decision.
Scalia's absence now on the court, will that affect the upcoming decisions? Meaning, if a replacement is not made before the court has to rule on some upcoming cases, the big upcoming cases this year are Whole Women's Health versus Cole, which is about the abortion clinic case in Texas. The other big case, Zubik versus Burwell, an Obamacare case where Catholic organizations and others don't want to have to pay for birth control in medical insurance for employees. So what will happen with these cases? Will the Supreme Court wait until a replacement is found before dealing with these cases? How does that work?
Well, let me just add a few others that are...
Yeah, go ahead. I'm sure there's others.
Huge cases this term, and where Scalia's vote would have been critical. United States against Texas, which has to do with the deferred action policy for undocumented immigrants that Obama, through executive orders, put in place. Another is Fredericks against California Teachers Association. This is the case that would have determined whether public employees must be obliged to be members of public employee unions. Huge First Amendment case. There's another one as well, and that's the affirmative action case before the Supreme Court a second time, Fisher against the University of Texas at Austin. His absence is likely to mean that each of these will be a 4-4 split. And in that circumstance, one of 2 things can happen. One, the court could simply announce in a brief per curiam opinion that the court split 4-4 and the lower court decisions stand. Or alternatively, they could bind them over for reconsideration once there's a full complement of justices on the court.
We're talking with Ralph Rossum, a constitutional professor in California who knew Supreme Court Justice Antonin Scalia, who sadly just passed away. We're talking about, what happens now. A member of the Heritage Foundation says the Supreme Court would actually know how Scalia would have voted on certain upcoming votes, and that the Supreme Court should cast a vote in the way that Scalia would have wanted, and they're basing this on preliminary votes that Scalia made before he died. Your thoughts on that idea from the Heritage Foundation?
I think that's a crazy idea. Too often, justices change their mind from their initially cast votes to going the other way once they read the written opinions of their colleagues. Several times Justice Scalia voted one way, read Thomas's dissent, and then joined that dissent. And so there's writing a majority opinion is, writing a committee report. You're trying to keep 5 votes on the same side. And sometimes by the arguments you make, you lose some of those votes. And the other side ends up winning. Think of the Obamacare case, NFIB against Sebelius. A preliminary vote is not a final vote and has no real relevance.
Very interesting answer. Talking with Professor Ralph Rossum, a constitutional professor out in California, on the back and forth that went on recently between Democrat Senator Chuck Schumer and Republican Senator Ted Cruz. Schumer says the current president, Barack Obama, should make the nomination of a justice to take Scalia's place. Senator Cruz says no appointments or confirmations should happen during an election year. Senate Republican Majority Leader Mitch McConnell said just this week that the U.S. Senate won't be approving any nominations or doing any Supreme Court appointments if a nomination is made. What are your thoughts on this whole issue?
Well, I think the president is obligated in the given a vacancy a nomination. The language in Article 2 of the Constitution is clear. The president shall, which means he's obliged to attempt to fill a vacancy. But the Senate is not operating under a shall provision, and they can advise and consent as they will. There have been lots of examples through time when the president has nominated somebody and the Senate has simply refused to take any action whatsoever. A lot of that was especially in the 19th century, but we can go back to the fall of '68 when Chief Justice Warren wanted to allow Lyndon Baines Johnson to name his successor rather than Richard Nixon, and resigned contingent upon his successor being confirmed. When LBJ nominated Abe Fortas, even though the Democrats controlled the Senate by huge majorities, they refused to act, in part because they found Abe Fortas morally and ethically suspect, but in part because they thought it was not fair game for a lame duck president to make that nomination. In addition, of course, to Schumer, Schumer, of course, has old videotapes have come out showing that he wanted during the final year of Bush 43 to ensure that Bush 43 could make no successful appointments to the Supreme Court. And we've now found the 1992 statements of Vice President Biden, then chairman of the Senate Judiciary Committee, who was arguing the same, that no Supreme Court nomination should be acted on if a vacancy occurred by Bush 41. So the Democrats have made the argument persuasively, as has Harry Reid. When he was majority leader, he made the same argument. We have conclusive evidence from major Democrats that what the Republicans are likely to do is a perfectly acceptable policy. It was acceptable for the Democrats, and now it's going to be acceptable for the Republicans.
Now, there had been talk about Brian Sandoval, the Nevada governor, but I guess they've backed off on that talk of Sandoval becoming a Supreme Court nominee.
Well, Brian Sandoval he was elected by like 70% of the vote to become governor in Nevada. He's the reason that Harry Reid decided not to seek re-election, because Sandoval, in all likelihood, is going to seek the nomination to be senator from the Republican nomination to be senator from Nevada. He served as a federal district court judge. He's got sterling credentials, but I heard just a brief while ago that Sandoval has pulled himself out of any consideration, saying he's not at all interested in being on the Supreme Court. So that's a very good thing for the McConnell and his pledge that they're not going to hold hearings or anything on any nominee. It would have been difficult, I think, for McConnell and the and Grassley as chairman of the Senate Judiciary Committee not to have held hearings and moved the ball forward had Sandoval in fact been nominated.
We're talking with Ralph Rossum, constitutional professor at Claremont McKenna College in California. We'll continue our conversation about Justice Antonin Scalia and what happens now. Back in just a moment. On the Newsmaker Show, Brian O'Neill on with Ralph Rossum, a constitutional professor at Claremont McKenna College in California. In your recent article, Ralph Rossum, you wrote on Antonin Scalia and his views on the Second Amendment. Second Amendment's a big thing around here with our listeners because it's a big hunting area, and in New York State back in 2013, Governor Andrew Cuomo passed what's called the SAFE Act. Now, the SAFE Act there's a lot of rules, but summed up the biggest part is that gun owners have to register certain weapons, long lists of weapons that have to be registered. And then there was a rule in the SAFE Act that makes it difficult to pass on weapons from one generation to another when someone dies. Wondering, Ralph Rossum, did Scalia have any thoughts on the New York State SAFE Act that you know of? Or how do you think, if not, how do you think he would have spoken on the SAFE Act?
Well, I would expect had a case actually come before the Supreme Court concerning some of those provisions that Scalia would doubtless have found a number of them unduly burdensome on restrictions of a fundamental right that he would doubtless have voted to overturn. Now, in his District of Columbia against Heller case, where he announced that individuals have this personal right to keep and bear arms for self-defense, he did say, obviously, the Second Amendment is not absolute. The First Amendment is not absolute. You're not protected if you engage in perjury on the witness stand simply because you're engaging in speech. And so reasonable restrictions on the Second Amendment were perfectly tolerable for Scalia. He mentioned, for example, preventing ex-felons and those with mental problems from owning guns. But when you get into a long list of itemized types of weapons that can or cannot be used, Scalia's argument was you should look and see to what extent they were understood to be weapons commonly employed for purposes of self-defense. And I would expect there'd be some problems with that list. I also expect there'd be some real problems with passing on property, handguns, rifles from one generation to another. There was a Supreme Court case just this past spring where the Supreme Court unanimously rejected an Obama administration attempt to prevent an individual who had a substantial collection of prized firearms from selling them. He'd been convicted of a crime which meant he could not possess weapons, and the federal government said, therefore, we get to claim them. And the Supreme Court unanimously said no, so long as this individual can secure a third party who will sell them to others and not back to the convicted felon. That's perfectly necessary and appropriate. The individual should be able to benefit from the sale of his prized collection of weapons. That rule there, I think, would be broad enough to cover attempts to prevent guns from being inherited by subsequent generations.
Talking with Ralph Rossum, a constitutional professor from California. Ralph, back to Antonin Scalia, who, of course, is what our whole show is about today, who will replace him, the process of how that goes. The legacy of Scalia, what is that to you?
So I wrote a book on Scalia, and in one meeting I had with him, I was asking him why he wrote opinions with the panache and the verve and the sarcasm and the wit that he did. Reading a Scalia opinion always would bring a smile to one's face. Whether you agreed with him or not on the outcome, he just was such a marvelous writer. And he said that it's very difficult to persuade fellow colleagues on the court. And so he wrote with that kind of panache and verve to ensure that his opinions were included in case books that law students would read, attempting to influence the next generation of lawyers. And in that regard, I engaged in a kind of empirical test. I went to every major case book in both the law school and political science market, and there were more Scalia opinions than any other justice. So he has had an impact that way. He's had a major impact on statutory construction, and his originalism. The fact that liberal Elena Kagan felt obliged to acknowledge that even she is an originalist, maybe not a very genuine or sincere originalist, but felt obliged to identify with originalism herself, just as is evidence of what a profound impact Scalia has had. He'll be regarded as one of the giants on the Supreme Court in the 20th and 21st centuries.
Your book on Scalia, what is it called and how do we get it?
Okay. It's called Antonin Scalia's Jurisprudence, and then in academic writing we have the mandatory colon, the subtitle, Text and Tradition. It's published by the University Press of Kansas, and it's available at Amazon.com.
So Antonin Scalia's Jurisprudence. It sounds like an amazing book and quite the important topic these days. Ralph Rossum, a constitutional professor at Claremont McKenna College in California. He was actually recommended to us by our regular Friday guest, and I'm so glad we had him on. Dr. Robert Heinemann told me that we should get Ralph on, and so glad we did. Ralph Rossum, I want to thank you very much for joining us here on a Monday.
Well, it's been my pleasure. I look forward to maybe being on to talk about my second favorite justice, Justice Clarence Thomas.
That would be wonderful. Actually, at the university that Dr. Robert Heinemann teaches at, Alfred University, Clarence Thomas was there in the late 1990s. And Dr. Robert Heinemann brought Clarence Thomas in to speak to a group there. Again, Ralph Rossum, it was great having you on today, and we'd love to have you back sometime to talk about Clarence Thomas.
Perfect. Thank you so much for this opportunity.
Thank you very much.